Morning, everybody. The session is now being recorded, so please accept it on your side. Thank you so much for joining us this morning, this being our last webinar for the year. Can you believe it? An entire year has come and gone. The recording will be placed on our website. You all know where that is. Today's session is going to be as interactive as possible, so please only mute yourself if you've got some noise in the background. Otherwise, please chime in, give your opinion. This is not you asking questions and me answering it. It is all of us talking together with our questions and answers, our thoughts. There's no wrong question or silly question or wrong or right answer. It is what we believe is correct. And then, of course, I think out of a session like this will come some interesting ideas for potential amendments to the legislation as well when it comes to interpretation and how things practically work. So I think that's the focus of today. Now, when it comes to the questions that we receive, obviously, we need to have a little bit of a disclaimer that if there's a potential conflict of interest and if the matter sounds very familiar, I'm going to unfortunately not be able to take a question like that. But if it is something that we can assist with, just remember it's based on what information you give us. And then, of course, that it is going to be as general as possible. And I'll try to give you an answer from both sides. Nicole and I late yesterday evening put together a bit of a list of some Q&A. Unless there's a whole lot of questions that you all have, perhaps we can get going with the first one. Nicole's going to keep an eye on the waiting room and let anybody else in, and she's going to keep an eye on the chat function for us as well, in case there's any of you that aren't able to speak but would like to rather ask their question in writing. So a client of ours recently contacted us to say they read an article that I think it was Nicole that wrote it about records in body corporates and what type of records need to be kept. And we're so ingrained with the fact that minutes have to be kept in perpetuity that we simply wrote in the article, minutes need to be kept in perpetuity. And the client came back to us and said, but where does it say that minutes need to be kept in perpetuity? And I immediately jumped onto the Sectional Title Schemes Management Act, Shirley's book, of course. And I was like, perpetuity, oh my goodness, where is it? Where is it? I looked in the Act, I looked in the management rules. Even though I knew it was in the management rules, I still went to the Act. I even quickly looked at the conduct rules. I was like, maybe I'm going absolutely off my head and it's there somewhere. And we looked and we looked. I personally looked 3 times. I think Nicole looked 2 or 3 times. We did the whole search function, perpetuity, minutes, records, 6 years, all that fun stuff. And we found that the keeping of minutes in perpetuity is no longer in the sectional title schemes.
Correct. You should have asked me, Zerlinda. I found that out when I did my index.
I thought using your book was sufficient. So that was quite an interesting question. Can you believe it? I don't know if it's me that's just slow on the uptake or I just assumed that it was there, but it goes nicely hand in hand with the concept of you always need to learn something new every single day in this industry. And there hasn't been a day that I haven't learned something new. And I think it was a day or 2 ago that was the thing that I had learned new. So that was a question that I assumed I knew the answer to. And of course, as Prof. Paddock always used to tell us, don't peacock. I peacocked with my feathers far out and said, yes, it's in the management rules. And then it actually wasn't. Shirley, can you believe it? I mean, that's definitely something that should be in. Then what we do is we amend our management rules and actually slot that in because I think it's vitally important.
I think it's very important. And I did what you did when I was checking. I mean, the fine checking of this book is amazing. I mean, I don't think I'm right in the head, but that's my opinion. Nobody else can think that. But I did check and check and check, and it is not there. And I mean, I've always assumed that it was 6 until I did that manual. And whilst we're on that, can we keep minutes on the cloud? Or do we have to keep them in hard copy and in the cloud?
Well, the old Act, now I mustn't go and assume something, I must always go and double check it, but the old Act used to speak about keeping it in a minutes book. Now it simply needs to be reduced to writing. So if you're able to print it off, that is in essence reducing it to writing. So it's not necessary to have those expensive hardcover books. I mean, Ruth, I know that you're online. At Pam Golding, they had those beautiful Horters books that cost an arm and a leg. And when I last spoke to somebody there, I think they said that Horters don't even make those books anymore. So I'm not too sure how people are keeping minutes, if they're still cutting them out and pasting them into books or they
We do that.
They take up so much space.
Yeah,
But
we
that's
still
only, how else do you do it? How do you keep it where it can't be tampered with?
Yeah, exactly.
And I
still
mean,
think-
really, that's vital because
Yeah.
we have wars sometimes, and the only thing you've got is a minute book that's signed. And that's why I get every page signed. I don't just get the last page signed. Every
Yeah.
page signed by whoever's signing the minutes.
It's a good idea.
I agree with Ruth. We've got to keep a minute book. We've taken over complexes where we've had to go back into their minutes, and we found things that they've said in various minutes or resolutions that have been signed that pertain to now. So yes, it's important that you have a minute book. I know they cost an arm and a leg, but it lasts forever. I mean, if they pay 900 Rand for a book, it lasts how many years? I mean,
Exactly. And it saves you in a court case.
That you can still get them from Bidvest Walton's stores.
Yeah,
So
we
they
get them all the
are.
time.
Thanks for that information, Tony. So I know, Ruth, this has been a bugbear of yours. I remember when I worked at Pam Golding that, people paste the incorrect things into the minute books as well. So I'd be interested to hear from you. I'd be interested to hear from you. What is the correct documents to paste into the minute book, but also what should you still keep on record from meetings?
My opinion, if it's a resolution, you need to put it in the book. If it's a decision, you need to put it in the book.
minutes, resolutions, everything.
Attendance registers, you need to put it in the book. Otherwise, you've got nothing.
And electronically, what are you doing now that meetings are being held electronically when it comes to attendance registers and things like that?
Well,
Can we use Meeting Pal?
Are you printing it off and pasting it in, or are you simply just keeping it on the cloud like Shirley mentioned?
So what I do is I do the normal register like you would have when you go to a meeting. I then snip the Zoom attendance thing and I stick that on there and I put that in my minute book. I also save the Meeting Pal, so I've got backup because that Meeting Pal is a book all of its own, and I find it quite difficult to just print the attendance portion of it. But I've got that as backup. But you on the Zoom, I snipped that. What do you call this thing? It says participants. So I snip that and stick it on my attendance register, which I've manually put in so that it calculates. So it all cross references, and that goes in the minute book because that's like one page, not 21.
Yeah.
That's the way I
And the participants, do you ask them to rename themselves?
do it.
You do it. Okay. All right. Interesting, hey? Gee whiskers. So
I also in the minute books on the AGMs or SGMs, I paste the entire agenda and document pack, because that provides critical history when you're taking over a building, and it's critical to have the history there, and that's what I do. I get laughed at, but you know what? It's priceless information.
So you go through quite a few of those Waters books then?
Yeah.
Oh dear. Oh dear. Yeah, exactly. We've got a couple of comments on the chat function. The minute books must be made available at the meetings. That's 100% true. You know, how many meetings do you go to as managing agents and trustees and owners? How many meetings have you gone to where there is actually the minutes, the sectional plans, the rules available at the meeting? I know with electronic meetings, it's now difficult, but physical meetings, do you make sure that that's done? Do you take your files with? Ruth, I know you've got Bibles. You literally call them your Bible per scheme and you take them with. Who else does that?
It depends who your
It
owners
makes it
are.
easier, hey?
Fantastic. There's a question: if minutes are not in perpetuity, what is the duration period? I understand records are usually 7 years for financials and 5 years. So I would still definitely amend your management rules to make minutes available in perpetuity, and we do that. It's actually 6 years for financial accounts and records. So the only provision in the Act relates to financial records, and that's 6 years. You know, when just before we left Pam Golding, we did a massive audit on the records, and we went through all the records to see exactly what they still had on file. And you know, as long as you've got the space to keep it or electronic means to keep it, then you must keep it as long as you possibly can, or at least while you still manage that scheme. And when you do a handover, like Tony mentioned, when you're taking over a new scheme, is to make sure that the new managing agent or the new committee of trustees have those records. But I would still keep minutes in perpetuity. You're always referring back to decisions and resolutions. It just doesn't make any logical sense to not keep it, or to keep it for only a specific timeline. All right.
Makes most sense.
Zerlinda,
Yes.
in real life, if I go to a meeting of my body corporate and I ask for the minute books, and the trustees look at you as if, where are you from? What does that mean? What in real life is the way to deal with this? I'm almost sure it doesn't exist, but do I need to go to CSOS and now claim from them to do it, or what's the practicalities of it? Nobody, none of the owners know that you should have something like that. The trustees either don't know or they don't want the records to be kept. So what do I do in real life?
So you say that the owners don't know and the trustees don't know. You know, they should know. Ignorance of the law is no excuse. They should know.
Yeah, but as I said, there's also sometimes the case where people don't want records to be kept.
Yeah, yeah.
So, you know, what is my situation as an owner now? How do I deal with this as a lone wolf?
Yeah. And unfortunately, a lot of owners are the lone wolf in their scheme.
Yes.
They aren't able to get the support necessary to, you know, 25% to call a meeting and all those fun things. So, you know, you could do things pre-emptory. So in other words, before the meeting, you can message your managing agent or your trustees and say, just a reminder that it is a legal requirement to have X, Y, and Z at the meeting, and then be able to point out in front of all the other members at the meeting if that is not the case. And of course, any record of the body corporate is available for inspection and copies by an owner as well within 10 days for records or 5 days for rules. And then, of course, if you aren't able to receive that for whatever reason, I know that a big reason that managing agents and trustees don't give the information is because of Poppy, and we can chat about that later if you guys want to, you know, is to go to the community scheme ombud service after that point. It's very sad that applications have to be made to the ombud for something as simple as getting access to records. And you mentioned that a lot of people don't want to keep records. You know, I've been to meetings before where I say to clients, you know, be careful what you say. Anything you say at this meeting is going to be recorded, especially if the meeting is audio recorded. Or be careful what you put in emails. That's even worse. You know, don't say something like that in email. If you want to, if you have to badmouth somebody, rather go, you know, go to your local pub or whatever and go and have a drink and do that. You know, that it's not in a formal type of setting, because those types of comments that you make are going to be recorded, and all owners have the right to that information. Many years ago, I dealt with a situation where an owner wanted to see the communication between a managing agent and the trustees. And what happened was the owner was legally entitled to attend at the managing agent's office, sit at the computer of the person and go through all of the emails. And they did that. They did that until they found what they wanted. So one needs to be very careful about what one says at a meeting, and of course, what one puts into email correspondence. But when you're a lone wolf, it is very difficult. And that's where the CSOS is supposed to be there to be able to help you. Whether or not that is always the case, especially in the grounds of urgency, is a whole other matter. So yeah, very interesting. I didn't think that that first topic was going to lead to so many discussions, but shall we open up the floor for something else?
Before we do that, Zerlinda, Gerard just asked now, is it not part of the agenda to investigate the minute books?
So the agenda deals with the approval of the last set of minutes of a meeting. So if you're at an annual general meeting, it's the consideration and approval of the last minutes of that annual general meeting. If you're at a special general meeting, you don't approve the minutes of an annual general meeting, but you could potentially approve the minutes of a last special general meeting. And of course, if you're at an AGM, you would approve not only the minutes of a last AGM, but an SGM as well. So you don't necessarily look at all the minutes, but as Aubrey mentioned, all the minutes must be available at that meeting.
Zerlinda, could I introduce a topic, please?
Yes, please do, Clive.
We've all been doing Zoom meetings, but sometimes the owners prefer a physical meeting for whatever reasons. So certainly from a voting point of view, I still tend to prefer physical meetings for some schemes. So we sent out 2 AGM notices. The meetings were physical. At that point in time, the whole COVID exponential curve wasn't here, but it rapidly caught up. And then we were sitting with the situation, do we cancel the meeting or do we switch to a virtual meeting? Now, this led to some discussion, and I see that one or two of my friends are here today. And I've got a bit of a networking group, and I've got quite a few interesting answers. So let's assume that we just stick with 14 days notice. 7 or 8 of those days have expired. The AGM is looming, and we now have COVID. We cannot have a physical meeting for obvious reasons, and we're not going to rely on a government announcement to tell us that it's going to be dangerous. The question is, can you change the mode of the meeting? Because the Act does not speak to virtual meetings specifically, as we all know. Can you change the mode without providing notice again? So some people would maybe object, others would not object. So I don't know if there's a right or wrong answer. Maybe the floor could just let us know what their feelings are on that.
So at the risk of Ruth telling me that I'm completely wrong and having another opinion, I'm going to ask her what her opinion is, and then we can open the floor.
Oh, that's not fair. We automatically at the moment send out dual. We've got bookings for January, and we're not sure that they won't even let us pay deposits because they can't guarantee that they'll be allowed to hold a meeting. So we actually just send out everything with a Zoom note, and if we're going to have a physical one with that address, and it just depends which way. It's gotten so far that one of ours has said, if you haven't been vaccinated, you can't attend physically. So it's going to be interesting times next year. The only thing we are really trying to push is that everybody uses the MeetingPal app so that we can actually comply and give immediate results. That is the most wonderful thing. So yeah, it is a bit of a catch-22.
So I sort of get that, and thank you for that, Ruth. I completely agree with you. So going forward, we've sort of learned that our new ones, we have a dual if the physical was opted for in the first place. But my question then is the ones where no notice has been given of the dual. So I think Ruth is definitely pointed out the logical solution, and I completely agree with that. But you're sitting with a window where maybe you have not yet sent out or thought about, and I hadn't thought about dual, to be honest, until this happened to us. So I don't know what the other thoughts might be for meetings that you now have where you cannot give the 14 days notice and you want to change the mode.
Anybody else before I jump in? Okay, so my first thought on that, and my first answer would have been no, it invalidates the meeting if you're going to go from a physical place to remote attendance, because I immediately thought if we were going to have the meeting at the scheme and then suddenly we realized that we can't have it at the scheme because there's no outside area to have it in, we'd have to all cram into somebody's units. Now we're going to go have it at the local restaurant, 5 minutes away, that would be the change of the place. And we all know that when we have an adjourned meeting, it must be at the same place, the same time, the same day. So there's obviously a reason for that. Then I started thinking about it a little bit more logically and practically. And Ruth, thank you very much for that answer that you gave. It's definitely a very logical and practical route to follow. And I don't have an issue with it from a legal perspective either, as long as you confirm beforehand how it is going to be, because you don't want half the people to rock up at the physical meeting and half the people to do the remote attendance if you aren't set up for the physical meeting. We must remember that the Act does allow in both trustee meetings and general meetings for remote attendance, although it doesn't speak about virtual meetings and it is archaic, and then it speaks about telephone. It does say other methods. So it is opening up the door to other methods. And then it goes on to say that it must be a method that is accessible to everybody. So you need to judge it from scheme to scheme. I have been involved in schemes before where people, for whatever reason, don't have smartphones. So perhaps a meeting app won't assist, or they don't have internet connection, or we look at something other than COVID and we say, what about load shedding? I mean, load shedding hits us, with a 2-minute warning. So in that case, many people aren't going to have internet connectivity, or perhaps they're going to be stuck in traffic now because all the traffic lights on the way home or to the meeting is going to be out. So things like that always need to be kept in consideration. I would not say that it invalidates a notice. if you are going to change from a physical place to a remote attendance, or even if you are going to later make it a dual meeting. And the only reason for that is because the Act does allow for remote attendance, provided that it is something that is easily accessible by everybody, that the chairperson with reasonable certainty can ascertain the identity of the parties, and that everybody can participate. So in other words, participate is that if I'm sitting on the other side of a Zoom call, I can hear what is going on and I can make my voice and my vote heard. So those are the characteristics. And if you look at, Microsoft Teams, at Zoom, at Skype even, it's all free. So if you were going to use some strange method that is not free and people had to pay a subscription for it, or they had to have a certain, like it wasn't compatible with a MacBook or something along those lines, and obviously it's not accessible. If you were going to do it in such an extent that you wouldn't be able to identify the person, and I have been on meetings where people haven't been able to be identified. And that's when, and I mentioned it to Ruth, you sign in with iPhone 265. Who is iPhone 265? Then the person mutes themselves and they don't unmute and they put their camera off. So how are you supposed to know who is iPhone 265? Are they the person that is now missing, or who are they? So that's a very big consideration in regards to quorum and validity of meetings. But to answer your question, in summary, it is not going to invalidate a meeting if you are going to change from a physical place to a remote place, or even from remote to physical, in my opinion. But I haven't dealt with remote to physical. It's always been from physical to remote.
Yeah, but also, Zerlinda, the electricity power failures, we've had that as well. I don't believe you can move a meeting for that, because if some people are going to be out of electricity, others are going to be worse, and then vice versa when you reschedule. So in my opinion, sorry for you, make a plan. That is not a reason to change a meeting. But in terms of the Act, whatever, the trustees also have to comply and make sure that they follow local bylaws. So if we have to change a meeting because the government gazette says we can't have it, well, sorry for you, that's just the facts. I don't think it invalidates anything. They are complying by ensuring that you follow.
So the changing the meeting, I think we were talking about the venue of the meeting only, not the date. I think when it comes to the load shedding issue, and I've also had a couple of questions like this, like 5 minutes before a meeting, load shedding is going to hit us now. Can we change the date? No, you're going to have to send out a fresh notice. Alternatively, what you could do is go ahead with the meeting, wait that 30 minutes, even though you're not going to get a quorum, and then have the adjourned meeting 7 days later, same place, same time, same day. So that's an option. Even though you're
not going to get a quorum, hey? Because remember, people overseas don't have power outages, so they're at the meeting.
They've got worse things.
Actually, quite interesting what you're getting now.
Yeah, very interesting, hey? It's not really simple anymore. Not simple anymore at all.
But it's nice because you're getting so many more people and such a diverse attendance, which really huge improvement on your locals that are just playing games.
Yeah, interesting, hey?
Part of being at the meetings.
Anything else? Same topic or different topic?
Okay, can I introduce the topic?
Yes, please, Aubrey.
I think there's more than one question going with it. The first one is the one I mailed you, and I think I got the answer, but you can perhaps just confirm. A management rule was registered in 2006 that a managing agent should be appointed. So is there anything that happened later on, except that if there's a unanimous decision that can overrule that instruction to the trustees? Perhaps you can just confirm that. I think I have the answer, but confirm, and then I have the next question on that.
Sure. So just to understand what the question is that instead of the option of appointing a managing agent, the management rule said thou shalt appoint a managing agent.
Yes, correct.
And did it say thou shalt appoint ABC managing agents, or just a managing agent? Okay, all right. So if that is written into the management rules, then the only way that you can change it is with the unanimous resolution, 100%. So the trustees don't have the discretion as to appoint or to not appoint. What we very often find, and it's normally a title deed condition, and it's sometimes for a retirement scheme that is sectional title in its nature, that it's written in that a certain type of managing agent has to be appointed, for example, CPOA, and that at all times that type of management agent has to be there. Sometimes it's written in that ABC managing agent is in perpetuity the managing agent. And if it's a title deed condition, that's not something that we can override. But if it is a management rule and not bound in the title deed condition, then most certainly by unanimous resolution, you can do that. And if you're not able to obtain a unanimous resolution, in my experience, we normally are not able to obtain unanimous resolutions because of quorum, as opposed to the objection to it. You can make an application to the Community Scheme Ombuds Service, but their threshold is quite high of what you needed to obtain before actually approaching them. But no, there is no discretion, and the only way that you'd be able to change that is with a unanimous resolution. Another question that could pop from that is, what happens if the body corporate doesn't have the financial ability to be able to appoint a managing agent? That's something to think about. So then the management rule would have to be amended. That's an interesting one. Yeah. What is your other question?
Okay, as that is a given, in my office complex, we want a managing agent to be appointed because of various reasons. I brought this to the attention of the trustees, and they had a trustee meeting and they voted that they do not want to comply.
No.
So where does it leave me? How do I go about it to, I've told them it's not something that you can vote about, but that's the vote. So in my understanding, the complex is captured now by trustees that decide they don't want to follow the law. Where does it leave me? What is my quickest, best way of dealing with this?
So your quickest way is to obtain support and call a special general meeting to direct to the trustees, because all you would need is an ordinary resolution. And the trustees have to adhere to that request by 25% of your fellow owners. But you mentioned that you're a lone wolf. And in that instance, the only other route available to you is the Community Scheme Ombuds Service. Although it's not going to be your quickest route, it is going to be the only route where you're not able to obtain support. In those types of instances, I would bombard the trustees with what they're doing wrong. I would threaten them with personal claims against them for their breach of their statutory duties, point out to them that they can't agree to not apply the law or the management rules, notify your fellow owners however you are able to, go put letters in their post boxes, get their email addresses, contact them, all those fun things. And you can do that all concurrently with going the Community Scheme Ombuds Service route. And hopefully you'll be able to resolve it before you're even contacted for a conciliation date. But if your management rule says you must appoint it, you must appoint it. It would be interesting to see what the reasons are for the trustees' decision. Are they simply saying we can do a better job, we're not wanting to do it, or we can't afford it? Because I think that would be the only reason not to adhere.
Yeah. No, well, in this case, and again, that's something that you don't normally would say, but there is the elephant in the room that I think they want to keep under their control. So it's a control issue. They've been there for 13 years. Basically, and lots of stuff that I don't believe is above board. Yeah. So by keeping control, obviously they, that's the purpose. I now managed to get the support of the trustees that is the minority. So can I ask them to be a part of the application to CSOS?
Definitely.
And that should strengthen the case.
Yeah, and you should also definitely point out to them that when it comes to, any order being made against the trustees, they aren't going to be able to escape it, even if they're in the minority. So you need to realize that as trustees, you're held accountable together. You can't say, oh, well, I didn't agree, then vote against any decision like that. Make your voice heard. You can't say, I was bullied, or the majority of the trustees said X, Y, and Z. All trustees have the responsibility to ensure adherence to the Act. Definitely interesting one, hey? Well, Aubrey, they're messing with the wrong guy, so I wish them luck.
Linda, may I interject on something here? When I was having this kind of problem, Aubrey, I actually also sent a letter to the auditors and said that I see things are not running very well, and I would like it, maybe there's a conflict of interest. I raised the issues that I had, and the auditors are bound to do something about it because of their regulatory bodies. And the trustees were not happy, but it does crack that's like close.
It's a good idea.
Thank you
Very good
for that.
idea. Very good idea. Fantastic. Any other questions? There's a question about the conduct of a tenant, which is the responsibility of the owner. Where is it stated in the legislation? So it's actually in the management rules. It's one of the first management rules. Shirley, let's see how quick we can get it in terms of your book. But when it comes to the compliance of conduct rules by your tenants, the owner is most certainly responsible. And that is set out in Management Rule 3.2. Clive, for that question of yours, there it is.
That's it. I've got it as well. I still use my book.
Good.
Very much.
I'd like to pose a question. So we very often get involved in, meeting attendances and things like that when the notice has already been sent out, and, we pretty much only hear about it a couple of days before the meeting is going to take place. But before I attend a meeting, I always ask the managing agent or the trustees to please send me the pack, because I want to, or the owner for that matter, because I want to make sure that, the meeting was called correctly. There's, proper documentation has been sent out. The resolutions have been properly prepared. There's nothing worse than going to a meeting blind and then realizing that you're going to have to defend something that was done incorrectly, or you haven't been prepared adequately for the owner. And something I very often come across is where there is letting of common property involved. And the resolution that is put forward is to allow the trustees to enter into lease agreements going forward. It doesn't specify what portion of common property, it doesn't specify who those tenants are going to be, it doesn't specify the amount, it doesn't specify the duration. Do you think that it would be a valid special resolution to allow the trustees to enter into lease agreements indiscriminately, in other words, not coming back to the members? Do you think that that would be a valid special resolution?
I'm not sure what you're saying. Are you saying there should be a blanket special resolution for all letting of common property?
So that's the question, is do you think that it is valid to have a special resolution proposed with a blanket authority to enter into lease agreements?
I do. But in that resolution, I do think every aspect should be mentioned, that like the caretaker's flat, if the caretaker's not living in it, in the storerooms at the parking bays, or they should actually be mentioned specifically what type of thing. I do, because it's not practical to keep coming back to a special resolution all the time.
Yeah.
Yeah.
I agree with you that it's not practical, but interestingly, one has to look at why the whole letting of common property is actually something that requires a special resolution. Remember, under the Sectional Titles Act, it used to be a trustee resolution. It was actually upscaled to a special resolution, and one needs to think about why that was done. And the reason for it is that a lot of body corporates circumvented the requirement of formalizing extensions of sections or creation of exclusive use areas by entering into lease agreements. In other words, it was a heck of a lot easier to simply get a trustee resolution to enter into lease agreements. So when it comes to a special resolution to enter into a lease agreement over common property with an owner or a current occupier, not an outsider, just an owner or current occupier, the legislation actually requires, even though it's not practically achievable, one special resolution per lease agreement. And a lease agreement cannot be transferable. It's for a owner or a current occupier. So that's quite an interesting one. And the reason behind it is really the intention of the legislature to ensure that when it is required, the route of an extension of a section or an exclusive use area creation or followed. So that's one that I want to acknowledge or know the answer to, but it is something that we deal with quite often. Sandra, I think you had your hand up for a second.
Sorry, I'm actually at the Drakensberg, so apologies if my signal is not great.
No worries.
I just wanted to, you and I have discussed it, but perhaps it's a good idea to actually play the scenario for the audience. Basically, what we're wanting to do in our body corporate is that we've got parking bays allocated to units, okay? The old scenario was that we had, say, for example, Zerlinda was living there, she moves out. That parking bay goes back into the pool, and then Shirley wants to move in, and she wants that parking bay for her second car. We would work it that way. But Zerlinda just explained now, it's better to actually have it allocated to a unit as opposed to Zerlinda versus Shirley versus Aubrey and so on and so forth. So it's a good idea to actually raise awareness with people in that sense. Then otherwise we're going to get into big fights about who this parking bay belongs to versus just mine. I've had it all the time. Why is unit so-and-so now taking it over? So yeah, that was my question. Thanks.
Very interesting here. There's a question about, and I'd like to hear the thoughts from the floor, is what happens when only one owner or one party agrees to be trustee? So in other words, you're at an AGM and you can't get trustees. What next?
Executive.
That's an option, definitely.
Well, Zerlinda, then that promotes the next question, because you would then want to ask for nominations from the floor. And then the question that rides on with yours is, can an owner nominate themselves?
Yeah.
I've come across that quite a bit, and I find nothing in the rules to say that an owner cannot. It says a member may nominate any person.
Yes, correct, 100%. And why can't it be themselves? And of course, if they're going to propose themselves, one assumes they're going to accept it as well, unless they're having a bipolar moment. But it definitely does happen. You know, I was at a meeting yesterday where 2 people made themselves available, but the members wanted 3. And they asked the question about what's going to happen to fill that 3rd vacancy. And when somebody made themselves available, that the other 2 didn't want to work with, the 2 of them resigned. So they were left with 1 trustee. What then? And they debated it amongst themselves until the 3rd person withdrew their nomination. And then the other 2 came back on board again. So I've been at a meeting before where I sat in a room for over 6 hours. The meeting went until just before midnight, until we got at least 2 trustees. The next day, one of them resigned. But, you know, I always tell people at a meeting that we're not leaving this meeting until we at least have 2 trustees, because 2 trustees can act as a minimum. And even if you resign the next day, we have to complete the business of that meeting. But that's an interesting practical problem to have, isn't it? So
Linda, could I ride on that? Could I ride on that question and ask if let's say 5 trustee posts have been called for at your AGM, you've got 5 trustees. 3 months later, for whatever reason, 1 is no longer filling the post, you've got 4 posts. The question is there, I know that the remaining trustees may at their discretion appoint a 5th to replace the 5th one. I understand that. My question is, are the trustees not really under obligation to do it? Because it is the owners, after all, who have wanted the 5. I've heard many different opinions on this.
So it's my view that they're not legally obliged to appoint another person. I do think that they need to consider it. They need to try. And most of the trustees that I work with do that. And they simply are not able to fill that vacancy because nobody is available. And very often they go the route of a professional trustee to fill that vacancy. But of course, that has its own resolution that's needed to get that approval. But it does speak about may versus must. So one has to read the legislation and look at the intention of the legislature. And there it does speak about, you know, it's a discretionary decision of the trustees. But I do think that they need to have a good reason for not co-opting another person. What we very often suggest is you go to the list if there has been more than the vacancies nominated, and go down the list of whoever was not elected as a trustee and offer it to them, or at least notify the owners that there is a vacancy, and should anyone be interested, that they must make themselves available to the trustees. But very often there is a reason, and normally quite a good one, as to why that vacancy is kept as a vacancy. Very often as well, an equal number of trustees is elected at an AGM. And if somebody steps down or resigns, at least that puts the body corporate in a position of an odd number to ensure that the chairperson doesn't have a casting and deliberative vote. So that might be a good reason to not fill a vacancy. But I don't believe that they have to fill it.
Then what happens with your minimum thing? Because if the owners at the meeting have said that the number must be 6, okay, your minimum 50% is 3. Now you lose trustees and you get down to say 4. Your minimum requirement is still 3 because the member said 6. I don't think it's the trustees' decision that, oh no, we're now going to just run it us without. Yes, I know they may, but the members can go back. It's either the members appoint another one or they appoint another one. But the members stated at the AGM they want 6 trustees. Your minimum requirement for a meeting then is 3. It doesn't change.
Yeah. So perhaps an option is to go back to the members, like you said, is to actually let the members decide what they want in those sessions.
If the trustees can't or won't or whatever, then it is a member's choice.
Yeah, definitely.
But I think the members stated 6 is 6, must stay 6.
Yeah, there's a couple of questions in the chat function. Can a request for copies of bank statements be withheld on instruction from trustees, or if the managing agent forwards these copies, certain information is blacked out? So bank statements is part of the records of the body corporate, the financial records. An owner is entitled to that. Very often I hear that, people's names are blocked out when it comes to their arrears. And the reason for that is POPI. So when it comes to POPI, POPI is just another piece of legislation as the Sectional Title Schemes Management Act is. And the Sectional Title Schemes Management Act, under the regulations, require that if an owner in writing or person authorized in writing requests that information, it must be made available to them, provided that the reason that they're going to be using it is not in contravention of POPI, that information must be made available to them. So to answer the question, it cannot be refused. And if the information is blacked out, that is also most certainly not something that is allowed. There was actually a CSOS adjudication order that was handed down, I think, during the course of last year. It was for an HAA, not a body corporate, but the same merits would apply, where the trustees did hand out records with information blocked out, and the adjudicator ordered that unfettered access needed to be provided to that information. So that's a very good question. The next one is it acceptable to describe the imposition of penalties for not adhering to conduct rules in the conduct rules itself, not the procedure, which is another topic? So is it acceptable to describe the imposition of penalties for not adhering to conduct rules in the conduct rules? Yes. So without a finding or penalty rule, the rules are pretty much not enforceable. The requirements of the Community Scheme Ombud Service is that the finding rule is at the bottom of the document, that it relates to all of the conduct issues in the set of conduct rules, that it does provide for a fining amount, that amount is not equal to or more than a levy, which is a subject on its own, and that there's a due process that needs to be followed there. For example, a warning, a meeting, and all those fun things. So yes, it definitely needs to be in the conduct rules.
Zerlinda, we also don't advise that people put the actual discrepancy in the conduct rule. So don't say barking dog equals 500 Rand fine, for example, because Zerlinda always says, oh, but my dog wasn't barking, my dog was yelping, or my dog was screeching. Or so we always like to, I'm that trustee, I'm that person that will always try and find the loophole. So we advise that the trustees just keep that as a separate document so that that can be applied equally, but not actually make that part of the conduct rules.
Mm-hmm. Aubrey, here's a question for you. It's from Nicoline van der Pol. Hi guys, I have a question about something I'm dealing with at the moment regarding consolidation of sections. A particular owner has purchased the flat next door and wants to break a doorway between the 2 units, but she insists that this is not a consolidation of the sections. In fact, she wants to completely renovate both units to remove the kitchen from one unit and turn it into another bedroom. So our argument is that this must be a consolidation of sections and she must follow the relevant process. Is there anything in the Act or the regulations that states that she can still keep these as two separate units, even if she's connecting the two?
Well, on the technicality, as far as the sectional title is concerned, I'm not the expert, but I think we should go back to the beginning and go to the site development plan first, if there's something like that, or otherwise, of course, the building plans. On the building plans, it will be two different inhabitable units. And that is what was approved. So all the plumbing, all the parking requirements, everything to do with this unit was done for two separate sections, two bedrooms or 3 bedrooms. The moment you change the use or you combine them and create one, taking out one kitchen, having more bedrooms and stuff like that, you have a new set of rules that will be applicable. So that would be the first step. So that can't be done before you have satisfied the building plan requirement. Of course, once it's one section, I think then from a sectional title point of view, I can't see that there should be much of a problem. If it was an original big unit, everything will change, and obviously it will have to become one section. You can't have two sections of which the one is not inhabitable because it doesn't have a kitchen. But I think the moment you ask them to rectify the building plans and stuff, they might decide not to do it.
So, Aubrey, I'm going to ask you in the new year to have a webinar with us, because I find your knowledge completely, exponential. And although you say you're not the expert when it comes to sectional title, you've been working in this industry specifically for so long that you most certainly are. Now, something else that you taught me recently was that when it comes to enclosures, it affects the floor area ratio, or what we all know as the bulk. So that's a very interesting topic as well. And I'd like to have a webinar on that. And perhaps we can deal with this whole consolidation and subdivision of sections at the same time. There's another question. Can members introduce a rule at an AGM that any trustees in arrears of levies can't stand or be appointed as a trustee if elected? Most certainly. So rules can be amended at an annual general meeting, provided the annual general meeting is called on 30 days notice. The notice is sent out by prepaid registered mail and all those things. And I know Ruth and I can have a topic of discussion based just on the way that notices are sent. But it would need to be a management rule first and foremost. And interestingly, the only reason that requirement under the Sectional Titles Act of a trustee being in breach of the rules and arrears with their levies, that they can't be made available or nominated as a trustee, the only reason that wasn't carried forward from the Sectional Titles Act to the Sectional Title Schemes Management Act was that the amendment to the Sectional Titles Act happened after the first draft of the Sectional Title Schemes Management Act was made or drafted. So it's a bit of an error that it slipped through the cracks. We've got a question from HAE1. That's a nice example of who are you with your name. But you've asked, you said, I've got a question relating to trustees that are on arrears, and you've got your hand up. Perhaps you can elaborate on that.
It is I, Tony Home Alive.
Hi there,
so
Tony,
sorry,
how are you?
Yes, fine. Here comes the question. It is really to do with trustees being in arrears. And I do know, you just say here that you could change the rules at the AGM. But the more practical approach would be one that I'd like to adopt. And that is, my conduct rules state that the trustees have to, the trustees have to uphold the conduct rules. That's inherent in the Act. The conduct rules state that levies have to be paid, which means if levies are not paid, then you are infringing the conduct rules. Then how would a trustee that is to uphold the conduct rules do so if that trustee is in arrears? And that's the question that I want. I just wanted to find out, what is the managing agent's moral position? Should the managing agent then take the matter to the trustees and say, you are in arrears, you either pay it or you are infringing the conduct rules, you can't uphold the conduct rules, therefore you may need to resign? I'd like the opinion from the floor. I felt that it was going to throw a sort of fox in the hen house, but I see with the attendance, I'd rather withdraw that one and just say it's like taking a chemical into a cannabis plant. So yeah, that's me.
What an interesting one. Before I open it up to the managing agents in the audience, I'd first like to say that you can't actually have, I'm just going to mute Angelique quickly. Oh, there we go. So thank you, Angelique. You can't actually have anything to do with levies in your conduct rules. It needs to be in your management rules, and that's a requirement of the Community Scheme Ombud Service. But let's ignore that for now. Managing agents, what are your moral obligations, or do you throw the morals out of the door because nobody cares about them?
Yeah, it's always a difficult one when you've got a trustee in arrears, and we've had many a battle, and you have to, you just have to follow the legal procedure to get those arrears paid. But let me tell you something, I'm sure you all know, the trustees in arrears make you jump through loops and hoops that you've never seen before.
Anyone else? Right. Ruth, here's one for you. If there are 5 trustee posts, 2 trustees resign and are not replaced, 3 trustees therefore remain, is the majority of the trustees then of the 3 existing trustees or the 5 original posts? It kind of goes hand in hand with your comment earlier.
Yeah, you see, so I believe then the majority is 3, because that's the members said 5. So everything works around that figure, in my opinion. I mean, obviously others will have other opinions, but I believe that's what the members said. Therefore, that's what it is. It has to always work as if they were 5.
It's a good black and white interpretation of the legislation, definitely, which I always try to stick to. If you had to interpret the legislation again, and I feel like I've said the word interpret like 100 times, but that's essentially what it comes down to, is that provided the number doesn't drop below 2, because that's essentially the minimum requirement, then it would be a quorum of the remaining. But it does start making it very, very complicated. And as Ruth said, you're technically acting against what the members have said. And if one looks at the fact that at an AGM agenda, you can have, or at an AGM, you have an item dealing with directives and restrictions. Is electing a certain number of trustees not a directive to the trustees? In other words, thou shalt do this. So that's definitely something to consider. So ladies and gents, we've got 3 minutes left, and I don't want to keep those of you out of the Women in Sectional Title webinar that's happening at 11. You are more than welcome to pop your questions through on the chat, and anything that hasn't been answered, I'm happy to contact you afterwards. But from Nicole and myself, I would like to say, firstly, thank you so much for everybody that has attended every single one of our webinars, or as many webinars as you've been able to attend, for participating, for supporting us. We really, really do appreciate it. I think we enjoy what we do more and more every single day. I have to admit that from mid-November, it was starting to wane a little bit, and I'm as exhausted as many of you are. A newborn baby might have something to do with that. I'm not too sure, but we are definitely looking forward to the new year. We're going to up the antes when it comes to our webinars and the guests that we have, and something that has been a desire of both of ours is to become more impactful when it comes to the Community Scheme Ombud Service and how people experience that. So if any of you have any issues with regards to the Community Scheme Ombud Service, I welcome those emails and those correspondences. I would like to assist as far as I'm able to. And I actually asked Nicole the other day, do we stay in the good books of the Community Scheme Ombud Service, or do we take the gloves off? And I would like to hear from you, as our colleagues in the industry, what do you believe would be the right way of dealing with these types of things? So I would like to see the industry change for the better in the new year, and I know that it is possible. Nicole has reminded me that we would like to invite you all to sign up for our newsletter. With that extra 5 minutes a day that we're going to find somewhere, we're going to start up a lovely newsletter and give you as much information as possible, and of course interact with you a lot more as well. For those of you that are staying home, enjoy it. For those of you that are traveling, please travel safe. Have a blessed festive season. Enjoy the time with the family and friends. And I hope to speak to all of you again in the new year. And if we don't see each other before then, we'll definitely see each other in the webinar that will be held in January. So ladies and gentlemen, thank you so much for joining us once again. It was lovely to see everybody, and have a fantastic day further.
Thank you, Nicole and Zerlinda. As always, all the best to you.
Thank you so much.
Everybody
Have
else.
a great festive season, guys.
Thank
Yep.
you. You all too. Keep well.
Bye.
Bye-bye.